Hello and welcome to today's legal and business Q&A session. We received an interesting question from one of our viewers, and the question is, does my company need a shareholders agreement despite having a MEMART? This is a common question among business owners, founders, investors, and entrepreneurs. So let's break it down. So to address this question, we need to address the following terms. First question, what is a MEMART? Now, a MEMART stands for Memorandum and Articles of Association, which is a constitutional document of a company. The memorandum sets out fundamental information about the company, such as its name, the object, and the structure, while the Articles of Association contain the rules governing the management and internal affairs of the company. Every registered company is required to have this MEMART, and it serves as the foundation upon which the company operates. Now, what is a shareholders agreement? A shareholders agreement, often referred to as SHA, is a private contract entered into by the shareholders of the company. It regulates the relationship between the shareholders and sets out their rights, obligations, responsibilities, and expectations regarding the ownership and management of the company. This shareholder agreement typically addresses matters such as decision-making, voting rights, transfer of shares, dispute resolution, exit arrangement, protection of minority shareholders, and other commercial agreements between shareholders. Now, what is the difference between the MEMART and the shareholders agreement? Although both documents relate to governance of a company, they serve different purposes. Firstly, MEMART is a public document filed with the Corporate Affairs Commission and can be inspected by members of the public. It's a public document. Whereas a shareholders agreement, on the other hand, is a private agreement between shareholders, which is generally confidential. And these shareholders could also be referred to as the owners of the company. Secondly, the MEMART governs the company as a legal entity, while the shareholders agreement governs the relationship between the shareholders themselves. Also, the MEMART contains the general constitutional framework of the company, whereas the shareholders agreement allows shareholders to create more detailed and customized arrangements tailored to each of their specific needs among themselves. Now, in simple terms, the MEMART provides the rules which governs the running of the company, while the shareholders agreement provides the rules which manages the relationship among the owners of the company. Now, if your company already has a MEMART, would you still need a shareholders agreement? Yes. The MEMART may not adequately address all practical and commercial issues that can arise among shareholders during the life of the business. A shareholders agreement becomes particularly important in this kind of situation. Now, what situations would a company consider having a shareholders agreement despite having a MEMART? Now, one, where there are multiple founders. Where the company has two or more founders, a shareholders agreement clearly defines each founder's rights, responsibilities, ownership interest, and decision-making powers. Another circumstance could be where investors are involved. Investors often require additional protections regarding their investments, including voting rights, board representation, information rights, and exit mechanisms. These protections are commonly addressed in the shareholders agreement. Another circumstance could be where minority shareholders need protection. A shareholders agreement can provide safeguards against unfair treatment of minority shareholders and ensure that their interests are adequately protected. Now, where there are restrictions on share transfer could be another circumstance, because if shareholders want to control who can become shareholder in the future, a shareholders agreement can include provisions such as right of first refusal, tag-along right, and drag-along right, as the case may be. Also, another circumstance is where the business expects future growth or funding. Now, startups and growing businesses often need a shareholders agreement to prepare for future fundraising, future strategic partnerships, and even changes in their ownership structure. Now, even when the shareholders want a clear dispute resolution mechanism, they require a shareholder agreement because it can establish procedures for resolving disagreements before they can escalate into costly litigations which may threaten the survival of the business. So in conclusion, does your company need a shareholders agreement despite having a MEMART? In many and most cases, I would say yes. Because while the MEMART remains the company's constitutional document, a shareholders agreement provides an additional layer of protection by addressing issues that are specific to the shareholders and their relationship with one another. Rather than viewing these two documents as alternatives, businesses should see them as complementary documents that work together to promote stability, certainty, and good corporate governance. Thank you for joining today's Legal and Business Q&A session. If you have questions relating to law, business, corporate governance, regulatory compliance, startups, investment, or any other legal issue, kindly drop your questions in the comment section below. We would be very delighted to address them in future sessions. Don't forget to like, share, and subscribe for more legal business insights. Until next time, stay informed and stay compliant. Thank you very much.